All right, so I'm going to try to turn on the web camera, which I've never used before. I'm not sure. I believe it appears at the top of your screen. So tell me if you can see. I figured this might be better for those that haven't worked with me in the past to kind of put a name and face together. So could somebody respond in the chat panel and see if that's showing, one, and if it's interfering with the slide in any way, because I've never used this feature before. Just waiting 1 second for somebody to type in that they can see and it's not interfering with the slide. Anybody? All right, so it looks like we're good. All right, so let's jump in. Excuse me. Welcome to the Micklin Law Group's webinar series. Every month we do one, usually on the last Thursday of each month. Today's webinar is your narcissist spouse hiding assets and guaranteed ways to find out? So without further ado, let's just jump right into it. All right, so let me give you a little background of what to expect from today's webinar if this is the first time that you've ever attended. It's scheduled for 60 minutes. I really don't do any rigorous timing. I just try to get through the information I think is important, and I stay as long as it takes. Hopefully you have the time set aside for it. If not, you can always get a copy of the recording, which will be uploaded to my website, usually in a couple weeks, and also into our YouTube page. It's a one-way communication, so hopefully you can continue to see and hear both me and the presentation, but I can hear you. I will take questions. I like to do them at the end, so that way it doesn't interfere with the presentation, but I always recommend that you write the questions down during the webinar so that you don't forget it when it comes time to answer them. You can do that with the chat panel or the questions panel. On your right-hand side should be a control panel that has a question section. So if you type into that, it should post it up, and then I'll get to them at the end. The purpose of these webinars overall is that I try to give so much information when I meet with clients and when I meet with consultations, and it's just not possible to go through everything that people need to know on any given topic in an hour or two, or in a consultation or before a court meeting. So I've started these a couple of years ago, along with the other information I put on my website, as an attempt to create a library of information or resources where people can go and answer just simple questions, but in much more greater depth. And then from there, you have a better sense of what to ask either me or anybody else about regarding your matter. There's also this PowerPoint presentation is uploaded to the GoToWebinar control panel, so you would be able to download it if you are interested. This one may not have that much of helpful information, but some of them in the past and others in the future will often have citations to case law and statutes that may be helpful for references. So you may want to use it for that purpose. Give a little background for those that have not worked with me or met with me. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I am licensed to appear in both state and federal courts in New Jersey. I started my career clerking for the Honorable Judge Eugene Austin, who was the supervising judge of special civil in Bergen County. From there, I did complex commercial litigation with Kessler & Associates for a couple of years, and then I opened my own office. I think it was in 2001. The Micklin Law Group itself is concentrated in divorce, family, and custody issues. I tend to handle more of the complex, either high net worth or high conflict cases, but we have several associates that handle different variety of issues and levels of conflict. Here are some awards I've received. Of those of you that have been in my office, I have most of them on my wall. I don't put these up to brag, nor do I put them in my office for that purpose, but it's really so that you get a sense of the kind of work that I've done over the years, the kind of dedication I put into both my cases and my clients, and that you get some sense that you can trust in the advice and recommendations that I'm giving you. These are a little outdated. I do have more recent ones. I probably would have to get these updated eventually, but obviously not tonight. So let's go through just real quick what we're going to cover. And just snapshot. First, we're going to talk about the common characteristics of narcissists, and I'll touch on some basic borderline personality disorders, and not a great deal because really, in my opinion, this information is good for anybody, but we'll explain when I go into it why we focus on narcissists. The initial steps, and I basically mean what you can do today and what you should start doing today if you have a concern that this is or may happen in your future. What records you want to look at and start to obtain. How to identify assets. I'll talk briefly about the basic types of assets, how they differ, and what's important to know about the different kinds when you are trying to document and research them. How to ascertain the value of both of simple and complex assets, because it will be separate and a little different for each kind, so you want to be prepared for that depending on which ones you may have. The difficulties, the types of difficulties you're going to have, why you're going to have them, and what you can do to try to get over them. What professionals you should speak with and what to do about that. And then lastly, the legal protections, basically how to protect yourself before it gets to court and even once it's there. So moving on to common characteristics of narcissists. And let me first say that before I get into this, my practice and my firm, we do a lot of work with narcissistic personalities and individuals because we found that it's a significant issue in divorces that's often overlooked. So I've done a lot of research, I've done a lot of webinars, and it's a focus that I put a great deal of time into, which is why I included it in this webinar specifically. But it's not to say that this would only apply to a narcissist, although they may be more inclined to do something like this. It'll apply to any case that could have assets and hidden assets. And also, when I speak of narcissist in this kind of a general topic, I'm really speaking of most borderline personality issues or disorders like histrionic tendencies, bipolar, not necessarily bipolar, but any borderline personality disorder will share similar traits that I'm about to discuss. But these are just kind of basics to give you kind of a heads up to determine whether or not you may have these issues in your spouse or your case. First is that they make false statements. And many people do that in a divorce case. But when I say that, I mean they make egregious false statements. They make false statements that are so egregious and outlandish that you're shocked and usually unprepared to actually address them because you would have never expected such a statement to be made in the first place. So knowing that helps you prepare in advance. They take an adversarial approach to the world. You're their enemy. If you challenge them or their self-image, they will come at you as if you were the worst enemy that they've ever faced. And that too you need to realize that in advance and be prepared for it. They're delusional, and I don't mean to the point of hearing voices, but more to the point of they will often blame you for the issues. Gaslighting is a very popular term where they try to project the issues that they have upon you, and they really, truly don't believe that they're doing anything wrong. And that's the important thing to realize about anybody in these kinds of circumstances, is that it's not like it's an act or that they're trying to do it to get over on you. This is what they believe to be the truth, how they perceive the world and their relationships. They take a black and white perspective, kind of goes around to the adversarial worldview that it's me against them, it's me against you. And again, when you attack them or challenge them, you're going to actually see how drastic it can actually become. Deviation from the norms, and I don't necessarily mean that they're abnormal, but they often conduct themselves in ways that are unique or an aberration from most people. It's often what leads to many of them being very successful, that they're very charismatic and they take different approaches. They sort of operate outside the box. And it's often effective, but it also can make them very difficult to deal with. And they sometimes have child or parental issues. I'm not sure now if I got this through my research or it's just something that I've noticed over time, but there's often a parental relationship, more often if it's a man with his mother, and you can see sort of a thread kind of going through the family that suggests that there's something more here than most other cases might have. So let's now quickly move into some basic or initial steps. And this is really just intended to sort of be on the lookout. So it's, you want to review your incoming mail. This is probably the best source for most people that are unaware. And I guess I should say the purpose of this webinar is addressing those that may be unaware of the assets that they have. We still often find Very traditional family setups where one spouse is a higher wage earner and another spouse is a stay-at-home parent. More often than not, one spouse over the other takes care of the assets and the income. It may not be always the higher earner, but it's often not a shared process. So the purpose of this information is to address those individuals that may be, or are unaware of the assets that they have. So the purpose of reviewing the mail is that you'll learn a lot from mail. Most people don't pay much attention to it, but it will identify, first of all, the accounts that they have and where they are. You don't need to know how much is in an account to be able to get it as a marital asset. You just need to know where to send a subpoena. And that's you're going to find out just by the return addresses on most of the mail that comes to your house. You will often get letters from your financial advisors, any professionals that you deal with. The accountant will normally send information, especially around tax season. Now, if it's not tax season, this is not necessarily the best one to be looking out for because you may not get anything from the account, but the advisors may come more often. And most importantly, you want to look for changes. If you've seen statements that have been coming in the past that no longer come in, or there are new changes or new statements that are coming in, or even if the statements seem different, like they used to come in a larger envelope and they're now smaller or vice versa, these are all just signs that should alert you that there's something that might be going on. Next is the certain documents you want to review. And obviously you want to review your tax returns. And I put up here the snapshot of your capital gains because this is going to be an important asset, or not asset, important document that you want to go to, and for many reasons. First of all, it's going to tell you just the assets here, but you want to look at everything. Here's the cost basis. That's what it was purchased for. You want to look there because you want to see what kind of money has been spent in the past on the assets. That in and of itself could suggest a dissipation or conversion of assets. And then of course here is the sale price. You want to know what it was sold for, which ties us over to here, whether there was a gain or a loss. The sale price and the gain or loss is going to tell you a lot because it would beg the question of why it's being sold, for instance, if it is at a loss. Now, sometimes you want to sell assets at a loss because you've had other gains. They may also just be an asset that's on its way down and you need to get rid of it. But the fact that it's being sold and whether there's a gain or loss at this initial stage is going to be very significant to you and very important that you track. So you want to look down through all of the gains and losses on the capital gain statements. I can't get my pen off. Oh, bear with me. Okay, we're back. So again, it shows what you have as well as what you've traded. I think I've already covered on that. Now is also, this is the Form 8960, but it's not necessarily, oh, hold on. Okay, 8960. With regard to reviewing your tax returns, you want to look at interest and investment income. This is one of the forms that may show it, but also it's likely, I believe it's also shown pretty well on the very first page of a tax return when they're listing the income. So you can see right there if there's interest or investment income, it will show up. Then you can come to this form to actually see what the specifics were. And again, you're looking for the same thing. You're looking for if something has been changed, if there are assets that may have either disappeared or appeared when your taxable interest, and you may even want to consider going through a couple of years tax returns and comparing these specific pages because you'll see, for instance, the taxable interest shouldn't change significantly in 1 year to the next unless there's been a significant change in your holdings, which would show up in the last form that we showed, your capital gain most likely. So these can show you, they will also suggest taxable interest can come from bank accounts, so that will let you know that there's other accounts that you need to look into that might be out there. Moving along on the same lines, as I mentioned before, you want to start looking for changes in your mail, in your change. Well, actually, with regard to that, if it stops coming entirely, you know you have a problem, and that does sometimes happen. They'll change their address, or they get a post office box. So you need to know if that's going to occur, that you have a serious issue. But like I said before, if there's a change or a reduction in the number of statements that you're getting, or the statements themselves change, you obviously want to look to make sure that there's any change in the accountants or your investment advisors or any of the other professionals that you're dealing with. That's a significant issue because, as we'll talk about later in the presentation, you have access to these people and you often have a legal right to get the information from these people. So your spouse may be changing them specifically to frustrate your ability to find and get the information from them. All right, so let's talk about a little bit about the records, which you want to get and what you want to do with them. First of all, especially if you're dealing with a narcissist, but if you're dealing with anybody that you think is hiding assets or likely to try to steal assets, you want to gather and copy every single thing that you can. You could never have too much information when it comes to getting a divorce. The more that you have, the better. First, obviously, you want to start with bank statements. That's the most important. To know where you're banking, it's where their paychecks are going to be going. It will also show you if their paychecks are no longer being deposited. There might be dividend checks. There could be profit share disputes. It could be anything that would normally be going into your bank account. By looking at recent statements, and not just the most recent statement, but several going back several months or even years if you can, will show you what used to go into your bank account and what the sources of the funds were and what might not now be going through. So again, it's give you a heads up that something is changing. Credit card statements, they're important for divorces. For assets, you only need these, or not only, but they would help you most if you're looking for money transfers, large payments on credit cards, possibly vacations. They might be going to take money to their family, or not necessarily usually like a Swiss bank account. We don't see that too often anymore. But credit cards can just show you sort of any aberration in their purchasing or in the people that they're dealing with. Closing statements from any real estate or businesses that were acquired while you were married. That will help you not only determine what is there, but also the value that will be important to establish later in your case. Investment statements, same as banks, bank statements, in that you want to get several years if you can to look for any significant changes where they're held, let alone in the amounts that are being held there. Income tax returns, as I said before, they're going to be much more helpful than most people realize, especially in those areas of capital gain and investment income that we talked about. You definitely want to spend some time going through those. And when you speak, if you are going to be speaking with advisors, you might want to ask them specifically questions about it, because most of us aren't that familiar with the different types of documents, especially tax returns. I find that the average lay person has no idea what their tax returns say or show, and they just sign them. So you might want to come to learn what that actually represents. Employment statements, pay stubs, and along with that, employment contracts. Obviously, pay stubs are important. They will tell you if there are mandatory retirement contributions or actually any kind of retirement contributions. They will sometimes tell you what other work-related benefits they have, like ESOP plans, but that's why you want the contracts. The contracts will tell you what they're entitled to. So they might have stock options that you're not aware of. They might be entitled to bonuses or compensation in the future that haven't yet vested or been received. And in some cases, people are able to direct when they receive it. They can defer receipt of certain assets until possibly the next year or another time. And you want to know what they have and what control they have over that, because assets like that are going to be not only marital assets, most likely, unless they're for future performance, which we won't get into here, but they may also be income, which will be relevant to an alimony issue. So it's very important to get the employment contracts. Don't overlook that when you come to assets and debts. Credit reports. Credit reports are great for understanding how people are using money. It may not go so significantly to assets that are being hidden, but it'll go to where money is being taken and what it's being used for. You may find that there's been a second mortgage taken out on your house that you didn't know about. There could be a business line of credit or even a home line of credit, a HELOC, that not only do you not know about, but you might not know how much the balance is or how much credit cards are being used. So if somebody cleaned out a HELOC, that will show up on your credit report if you don't see the statements. Important to know that you need their permission to get theirs, so it may be difficult for you to obtain it if you don't already have one. But if you've purchased real estate recently or opened a business or even taken out a loan, there may be other sources that have copies of it that you'd be entitled to get. I also recommend that you get your own. A lot of people first don't even know what kind of credit they have outstanding. Again, in the traditional relationship, one party handles these decisions and the other party often is just signing paperwork. So you want to get this just not only to see what you have, but also for asset protection. And then a lot of times, a lot of people unfortunately find that their spouses have taken out credit and loans in their name fraudulently and that they didn't know about it. And you need to know that right away because it becomes a significant issue whether or not you report it as fraud, whether or not you want to reverse it, and you want to find out where the proceeds from these extensions of credit went to or were used for. And of course, you want to have the names of your advisors and the accountants, especially if they're going to change. If you were not the one that was involved in the relationship with these people or in the exchange of information and production of documents, you may not know who they really are. And if they are not being used anymore and records are cleaned out by the other spouse, you're not going to find out who they were. So you want to get it, make a record of it, even if it's just making a note, in a notepad so that you can locate these people later. You definitely want to know who they are and where you can find them. All right, so now we're going to talk a little bit about identifying assets, and I'm going to talk about two types of assets that are important for understanding. One is active assets and one are passive assets. Now, there's also going to be a need to understand pre- and post-marital assets. I think most people kind of get that understanding, so I'm not going to get into that. But when it comes to active and passive assets, both active and passive can be both post and premarital assets. So that distinction is going to be important, but not necessarily for today's webinar. So let's first talk about active assets. Active assets are assets that change in value through one's effort or through both of your efforts. And it doesn't necessarily mean the physical effort. It can mean just the contribution of maintaining a household or raising a child or working so that another party can open a business and manage it. So the most common are going to be business interests and marital residence. And again, both of those because you jointly are contributing, even if you're not the one running the business or even if you're not the one at home with the children, the joint effort is what makes it active. And the reason it's active is because it's the effort of working the business or the effort of paying the mortgage down and building a family that make the assets valuable or more or less valuable. Then there's passive assets. Now, passive assets are obviously not the same. They change in value because of market conditions. Market goes up, your assets go up. Market goes down, your assets go down. It has nothing to do with your efforts or your control over them. Most common are going to be investment accounts and investment properties, meaning not your marital residence. If you have a commercial building that you don't live in, or you have a house that you lived in before but now you're renting out, that's not an active asset. It's a passive asset because it's commercial or it's deemed commercial. Now, on a quick aside, if you live in a two-family, that's a little bit of both. So again, not an issue we need to get into for this webinar, but it is something you need to understand that may affect the value of that property. All right, so once you have an idea of the assets that you have and also how the values are determined and change, you want to figure out how to go about getting the value of them. So first, you want to go with the opening statements. If you can, go back to when you first opened any investment account. And sometimes you can get that simply by calling the company. If it's a joint account, you can go through records. Opening statements also meaning the time that you opened the business. You might want to get a bank statement, any kind of closing documents. If you bought or sold real estate, you want to get those statements. You then want to get the most recent statement. You don't necessarily need to get everyone in between, although it wouldn't hurt. But then you get the most recent statement so you can see the change, especially when it comes to investment accounts. You want to see what is there both in value and in holdings. Don't neglect just because the value may have changed doesn't necessarily mean assets haven't been taken out and transferred away. Valuations, if you need to, you can actually hire people to evaluate certain assets. Most commonly, most importantly, you're going to have business interests and real estate. You can do real estate. I think it's Zoom.com gives you some idea of real estate. You can also call real estate brokers or salespeople. They can often give you a comp analysis, which is a comparative market analysis. That will sometimes give you at least some idea of the value of your house or of real estate. You may want to try to get that back to the date of the purchase also, so you can see what the change in the value has been. And then, of course, there's expert witnesses, which you may not necessarily do at this stage, the investigation stage, but you can. It really depends on your financial standing and the significance of the assets at issue. I'm not opposed to you getting an expert even long before litigation has begun, so that you can start to determine the value of these things. So when you do get into litigation, you do find yourself in the divorce, then you're armed with the information, as opposed to, in most cases, you're starting to get it when the case starts, and then you're kind of climbing uphill trying to get all of it and trying to get it as quickly as possible. So let's quickly move along to some of the difficulties. Not necessarily difficulties you're going to have, but the issues that are difficult to prove and protect. First of all, cash businesses, very difficult for very many reasons. One, cash businesses are hard to determine if there is an attempt to conceal income, because again, it's cash, so it's hard to account for. There's often also an issue with cash businesses in that there's a tendency to underreport income during the term of your marriage, during the time of your marriage. So it's hard to then later argue that the individual running the business is hiding cash when the records of current cash don't differ much from the records of the reported cash. The issue being that they didn't report all of the cash. This is one case where you may need to have an expert come in and evaluate it. You could also consider getting a confidentiality order of protection with the expert and in the litigation, so that you can get the information but not worry about any kind of underreporting sanctions or penalties that could come up. Again, another issue for a different webinar, but something to be very cautious of. Cash assets, meaning just cash, very difficult to prove. I can't tell you how many people come and tell me that their spouse has a safe in the house or a floor safe, and there's $70,000 in cash or $30,000 in cash, and that they took it. And that they often knew it was there the whole time. If there's cash assets and there's going to be a divorce, it's going to disappear. I generally tell people, if you have this type of asset and you think it's going to disappear, then you should take it yourself or take half of it. Just like a bank account. If you have a joint bank account and you think your spouse is going to clean it out, then take it. Either take all of it or at least take half of it. Nothing inappropriate about taking half of a joint asset, because it's hard to account for cash. If it's gone, you can't prove that it was ever there. And it brings that underreporting issue that existed with cash businesses. Foreign or international assets, that will usually show up on your tax return. There is a place in a tax return for foreign investments, but it's hard to value a foreign asset. And it's also hard to trace if one is going to disappear or be traded. This is why all those steps before this are so significant, to start determining where your statements are coming from. If you're seeing international mail and all of a sudden it's disappearing, then there's a good chance that there might have been an international or foreign asset, and that too is disappearing. Past transfers, and more often than not, these are family gifts or transfers. The issue, not first of all, it's hard to document this and hard to prove them because it's often usually small amounts or modest amounts, but over a very significant period of time. It could be a regular transfer that's being sent. Now, part of the issue or part of the difficulty that you're going to have with this, one is tracking it because, again, it can be over long periods of time. It may not have even been done through a bank account. It could have been through a Western Union or a wire transfer. As a matter of fact, if you think that's the case, you may want to go to either Western Unions or whatever check cashing places or money transferring locations are anywhere within, let's say, 5 miles of your home or your spouse's workplace. Generally, if people are going to be transferring money, especially out of the country, they're not going to go much further than a few miles from their home. So you might want to look in that direction. But the second difficulty you're going to find is even if you've been able to trace this consistent flow of money, you have to show that there was an intent to hide the money. Not more often than not, but quite often, the money is being sent to family members as a form of support. A lot of ethnicities and a lot of traditional families are sending money for the support of their elderly parents. So they may argue that that was it. I think it's important to determine what the intention was when the money is being transferred, but also the size of it. If you're seeing sizable transfers, it's not likely for the care of an elderly parent because they don't usually require that large of a subsidy. So it's a difficulty that you need to work on, but you need to start thinking about that now. If you see that there are transfers going out to a family member or some kind of constant transfer, or if you think that they're going to start doing it. If they start doing it, it's a lot easier to prove that was for the purpose of divesting the court of jurisdiction or of hiding it from you. Speak with professionals. The most important you want to start with, obviously, is your current advisors, because they're going to know not only everything that you have, they're going to be able to see if there's been any changes, any abnormal transfers, a change in the risk profile that you generally fill out, abnormal trading, anything. Maybe even been conversations about the need to transfer assets. If they're joint accounts, you certainly have the right to get this information. If they're not, most advisors will still speak to you knowing that you're the spouse, unless they've gotten information to say that you shouldn't, which is also a red flag to move forward. Your accountants, obviously, a good place to go to. They will generally have all the financial information or most of the financial information. And there's not usually, there's most likely going to be a joint tax return, so there's no confidentiality issues. Can't be anything that's barring them. If you discover that there are new advisors or accountants, you definitely want to get in touch with them. Now, this is, again, more of a red flag if you start to see something like this, but it doesn't necessarily mean you want to run into court right away with this information, but it's something to be ready for. And last is consider private investigators. Private investigators aren't like they used to be, in that it used to be you had to pay $200-300 an hour to have people sit in a car and follow people, or to go all day and walk into banks and look for accounts. It's a lot different now. Given the access of information that the internet has provided for us, and an experienced private investigator will also have a lot of connections in financial institutions and just a good knowledge of the best ways to approach locating assets and possibly hidden assets. It's a very good consideration. A lot of people refrain from it because they're afraid of the significant costs. But I think that's a mistake. When you have assets, significant assets that may be disappearing, you want to do everything that you can to find out everything that there is. All right, so now let's talk a little bit toward, and we might be coming to a relatively early end for this webinar, the legal protections. First of all, as I may have been saying throughout most of this, you want to document and note every single thing you can. If you can, make copies of them. If you can't, just write it down. Write down everything that you see that comes in from any location. Make a note of what you've noticed that may not be coming in any longer, anything that's changed. The more that you can document, the better off you will be later. And that later being when you find yourself having to file in court. So obviously you have two, I think, main choices when it comes to actually having to go to court. The first is obviously just filing a divorce. When you file a divorce, it accomplishes many issues, or it accomplishes many things for you. First of all, it preserves the equitable distribution date, which means that the clock stops running at that point. So if you file today and he transfers assets tomorrow, or he transfers money to his family, none of that would matter. You're still entitled to what existed at the date of your filing. Now, if it's an investment account and it changes because of market condition, that's a little different. That goes back to the active passive distinction that I mentioned earlier, but I'm not going to get into that. It's just important to know that the court kind of takes a snapshot of your life, and whatever assets were there are now subject to the distribution. So it doesn't matter if they're later transferred. They either have to be returned or they're offset by some other asset. Second, and probably more importantly, it begins what's called the discovery period, which is the exchange of information. It now allows you to, or your attorney, to issue subpoenas to the financial institutions to get all the records. It allows you to go to financial advisors, accountants, any other institution or advisor and get all the records, not just statements, but any handwritten notes they may have, any instructions, any emails. This, and it's under the authority of the court, so if it's not provided, you now have the court's sanction ability to compel the production of these documents. You can also take depositions of the advisors, put them under oath, and find out what conversations they've had, what instructions they've received, and any other changes that may have been direction, and how that direction was given and why. Second is something called an order to show cause. An order to show cause is an emergent application that usually gets hand filed in the court that says, for whatever the reason is, because you can file an order to show cause, in almost any court for any type of case. But basically, you're saying to the court that there's an emergency that requires the court to act immediately, and either or, one, enter immediate relief, like a restraint on the transfer of assets or a restraint on the conduct of a person, and to schedule a more expedited return date. Like, for instance, when you file regular papers in a divorce case, which are called motions, the motion is scheduled for 1 month from approximately 1 month from the date that you file it, and often gets moved to later dates. So it's often several months before the application is actually heard. An order to show cause may get a hearing date in a week or two, and you can bring it in tomorrow. You can bring it in as soon as it's prepared and ask for emergency. The thing about an order to show cause, it's an emergency application, is that when it comes to financial issues, more often than not, they're not going to be granted for transfers of assets, even significant transfers of assets. The general belief is that financial issues are not emergent. And that's easy for a judge who's sitting, behind a walnut desk to say that. When you have, your whole life savings disappears, that becomes very urgent to you. But more often than not, you won't get at least a temporary restraint. You won't get like a freeze on the accounts or an order for an immediate return of the assets, which you may get. But what you more often will get, at least, is a more expedited return date. And sometimes that's just as helpful as getting a restraint. Because if you have to wait several months, then whatever was just transferred may either disappear or may get transferred even further out of the reach of the court. Now, that's not to mean that if your application is not successful when it's transferred, it's gone. It's going to depend on the type of asset that is being transferred. Like I said, cash is hard to stop, and once it disappears, it disappears. Most other assets that have to be transferred or are not liquid, like investment accounts or real estate, where you can't just take all the money into your hand, may be transferred or usually can be traced and returned, and they will almost always show up on a tax return. So it's hard to take large sums of money and just have it disappear entirely and quickly. But it can happen, and that's really what the purpose of this webinar is to understand that it can happen and the steps you need to safeguard yourself on it. Now, that's generally the information. I know it was a very limited topic, so I didn't take a great deal of time. I hope that at least I gave you the guidelines to determine whether or not it's happening. This isn't about fixing it. This is really about determining if it's happening and how to take immediate action so that you're protected against it, and that any assets that are transferred get returned to you and equally divided or equitably divided. With that, I'm going to see if there's any questions, and as I said at the beginning, I'm going to stay as long as needed to answer any questions. I'm not seeing any questions. Again, there's the questions section, and you should just be able to type right into there. Not seeing any. Hopefully everybody can still hear me. I haven't gotten any notes that nobody can. It's unusual. Okay, so so here's a question. Order show cause. I'm just going to read it out loud. My understanding is that, excuse me, nobody that signed in can see the names of anybody else. So when I read the question, I'm not going to obviously identify who it is, but I'm going to read it out to make sure it's clear and that you wrote it the way I'm hearing it, and then try to answer it. So order show cause was filed, owed over $400,000 in the middle of trial. It's 13 months now. How could an order show cause take so long? Well, the resolution of an order show cause can take as long as it takes. The order show cause is just the expedited filing so that you get into court in a day or two and you get a hearing usually within a week or two. But depending on the nature of the application and the relief sought, it may turn into litigation. It may then become discovery, like I talked about, the gathering and exchanging of financial documents, depositions, or could be hearings. However, if the order show cause was simply over that and that issue has been litigated for 13 months, it's probably the person who transferred its attempt to frustrate your ability to get it back. It's a significant amount of money, and I'm sure a lot of it is being eaten up in legal fees. But what you want to try to do, and this would actually relate in the very beginning of a case, but even now, given that you've been in litigation for so long, you want to try to get the money held somewhere as sort of a safeguard. Attorneys can put it into their trust account. You can get an interest-bearing trust account so that you can earn some interest, although not a significant amount, but that it's controlled by the lawyers in the case so that you know at least the asset that you're fighting over is still there. It's not being squandered or dissipated further. So, I mean, that's my general take. It's not shocking that it would take that long to resolve the issue, but it does also suggest that there could be some intent to purposely delay it. Hope that answers your question. If not, just type in a new one or a further explanation for me. Any other questions? Like I said, I'm more than happy to stay as long as we need. Finished a couple minutes early, so going once, going twice. All right, so most of you, actually probably all of you, should have gotten emails about this and has my email address. Oh, you know, real quick, before I sign out, but let me finish my thought. I was going to say, if you have questions once we disconnect and you feel that you should have asked them here, just send them to me by an email or give me a call at the office, 973-562-0100. Another question popped up. Looks like they didn't finish typing it. So I got if one is living separately. The individual who typed up a question about one is living separately. Okay. All right, so one is living separately, and then they build assets while they're living separately for a year. Everything still have to be divided. It's going to depend on many things. I mean, the beginning answer starts with yes because you're still married, and if you are separate but you elect not to file for a divorce, you're implicitly saying you intend to stay married. So the argument is, if you wanted to be separate assets and divorce, you would have filed, or separate assets and debt, you would have filed for a divorce, and you didn't. But then the question really becomes, one, what was the source of the funds for the acquisition of the asset? Was it marital assets? Was it work? Was it earnings from your work, which after separation may not necessarily be marital assets? If it's a post-separation and the other spouse was no longer contributing to raising children or maintaining a household, you can make an argument that any asset that you bought post-separation should be yours to keep if it was used with post-separation assets. But better chance than not, it might still be counted as marital asset because you did not file for divorce. And to some extent, even your earnings while you're married are marital assets even after your separation. So I wouldn't recommend it if your plan is to purchase assets before filing for a divorce. I wouldn't recommend it. If there's a post-nup. Well, that's different. Oh, post-nup, maybe. Depends on what the post-nup says, obviously. But the thing about post-nups is they're still generally believed to be coercive, more coercive than a prenup. The mentality in the judicial community is it's a sign this or I'm divorcing you. So they believe that to be coercive. Now, I think a prenup is much more coercive than that because it's sign this or we're not getting married. I think people call off a marriage a lot more quickly than file for divorce, but it's my own opinions on that. So if your post-nup is valid, drafted well, and fair, meaning there was adequate disclosures of assets and debts, the terms are relatively fair, there was legal advice on both sides, and then you acted in accordance with it, then I would think, yes, it would be yours, not only because the prenup contractually entitled you to do that, but more importantly, you relied on the post-nup contractually allows you to do it, but then you relied on the post-nup and you changed your position based on that. That's another contract, quasi-contract legal theory, and especially in family court, which is what's considered a court of equity. It means a court of fairness. They rely on principles like reliance, like justifiable reliance. If you justifiably relied on your agreement and now you were harmed because of that, court may still say that you have the right to do it. Hopefully that answers your question. All right, I'm looking for any other questions or any other comments anybody wants to make. Okay, so I'm going to take these pictures. Oh, we got to update them. I'm going to take a minute just to launch a quick survey, like a poll, just to find a little information about this to see if this is good for you and if there's any way we can improve this. So just take a second, plug in the answer here if you can. All right. Well, that's interesting. Okay, good. Probably our emails. Next, just a couple of these. Now this one's important because I changed the time. We used to have these at 6:30, and I got the sense that maybe that makes a work pressure for people, so I decided to push it back to 7. Okay, good to know. Just a couple more. Okay. This one's most important. I want to make sure that I did cover everything that we need, and also so I can plan for future webinars. To a couple people that still haven't voted, if I could just urge you to quickly vote just so that I know. Again, I use this to plan future webinars, so it helps me to know if we covered everything properly. All right, so they didn't vote, but we'll close it anyway. Well, at least those that voted are satisfied. Good. And last, Okay, well, and for those that said maybe, you certainly can give us a call or send me an email. I'm not going to reach out to you. I just don't want to. These webinars aren't for the purpose of getting clients or businesses, really just to help people and share some information. So if you are interested, feel free to contact us, 973-562-0100. Our next webinar should be scheduled for July 27th, which is the last Thursday. I'm sorry, I don't know the title, but let me go to my website real quick. It's actually not even posted. I think it might be on misconceptions in divorce, but I'm not sure. I think that was what we proposed. I'm also considering something along the lines of like the top 10 secrets that no other lawyer will tell you, some things I've been working on that I think really kind of cut to the heart of a lot of issues in divorces. If that's not next month, it will be in the next couple months, so keep an eye out for that. With that, I thank you for joining us. I hope I gave you some helpful information. If I could be of any assistance to you in the future, certainly let us know. And with that, I wish you a good night. Thank you.